Let's see originals.
Okay. We do have copies and I assume everybody's read them. I don't think we need to read them again, but I appreciate their comments and I, I don't have anything to add to it. I mean, the thing speaks for itself, so. For the audience, land use planning just wrote us a letter saying they were concerned that we were not following the land use planning document, the county policy that we use, that the Tipi Retreat application was reviewed and actually did go to court, and the judge found in favor of the county in that issue. They did find us arbitrary on a couple of those issues, but it only takes one absolute policy to not appoint it. And subsequently, and found that our plan was legal, and then subsequently he did in a trial to decide the penalty for their illegal use of their property, fined them $40,000. So the land use planning committee and the planner, I assume I don't want to speak for you, Les, believe that that process was done. If there's new information, that it should come back through a new application, and which I agree with. I think it should come back through a new application, and there's been a lot of new information gained from both sides in this process, and I think the application process will go a little different in things we understand. And I just the one thing that I don't think we gave much consideration to was how that original road came to be. And the land use planning did talk about it a little bit, that it was basically a taking by the county for that 30-foot easement for a private residence. I don't think they ever intended to grant a commercial easement. And in fact, I believe they paid those people based on a residential access. So for us to go and grant that without a right of way, I think opens the county to liability from the neighbors to sue us to say you're actually creating a taking of an additional 30 feet. So the commission here is that condemnation happened by the county commissioners, I think in '97. Anyway, all the land use planning board is asking is for us to consider it, go back through the process, add another month to the process, but I think it would help us, and it would also not set a precedent to circumvent the land use planning commission. So, and they do ask us specifically to address consider the potential risks, implications before proceeding with the proposed public hearing, and asking us whether we want to continue using the land use planning document, which in our discussion has been tried in court and found to be legal. So, that was one good thing that did come out of the Tipi retreat. And anyway, if you guys have comment, I mean, that's one. Let's see if I can find here.
I've got some responses to these letters.
Okay. It says we seek clarification on how the county plans to balance adherence to its established process with flexibility to address unique contentious matters in a way that minimizes risk and maintains public trust. It talks about anyway, So.
I've heard, Mr. Chairman, I've heard from both sides. I've heard that, the Tipi, Stevens have said they requested, to seek remedy and they were not allowed. And then I've heard from the former commissioner that they were given the opportunity for remedy. So I think the truth is going to be somewhere in the middle. And my belief on seconding the motion last week was to give them an opportunity. We're not guaranteeing anything. We're not guaranteeing any results. All we're doing is putting to the public that there was an opportunity for remedy.
So that, see, I don't know. I don't know that it seems to me that, we made the motion, they came to the hearing with their lawyer. And as soon as we made the thing, it wasn't very long, they sued us. So once it went to litigation, then it's in the hands of the court. So the remedy went through the court. And we prevailed.
I don't believe this would be we're not guaranteeing Stevens or the county anything.
Well, see,
By having this meeting, all we're doing is letting everybody present their information.
no, that's not, the motion was to go through the checklist,
Mhm.
follow the procedures for a land use change. So in order, when you start down that process, then the motion was to go through those, go through the checklist, absolute and relative. The whole purpose of that is to decide whether to grant the land use change. It's not just a public hearing for a hearing of everybody's side. It is to grant them a land use change. So in my estimation, it circumvents the process. But we also,
I've got explanation.
so we also, you're gonna go through the checklist, but you do not have an application. That application is done. You have to have a new application in order to score the checklist. I know you're brand new to the process, but the way it normally goes through the process is there's an application. Planner works with the applicant to make sure that it's all the stuff we need is in there. So it's not a last minute thing. And then they schedule, they advertise a public hearing and they schedule the land use planning board. I'll let Les, he's the planner. You
Yeah, so there,
explain the process.
yeah, so there's two notifications that go in the paper, that it's gonna go before the Land Use Planning Commission. Then it is reviewed by the commission and they score it. They also do the absolute and relative policy checklist from the information I provide them along with the information they've gathered themselves. And then they do either a recommendation to the Board of County Commissioners of which way. They're either in agreement or disagreement. It still comes to you guys, goes in front of a public hearing. You guys do your own absolute and relative checklist. You've got the opportunity to ask questions of the applicant and myself. And
For the people that present.
or
The public.
anybody at the public meeting as well.
Did the Stevenses go through that originally?
Pardon me?
Did the Stevenses go through that original?
To my knowledge, yes.
Did the judge ask for a remand?
Did the judge ask for it to come back to the Board of County Commissioners? Is that what you're asking?
Yeah.
No, they didn't. To my knowledge, he did not.
They did. The judge did. In fact, the judge's quote was, as stated by Tipi Retreat asserts that the board did not make sufficient specific findings of fact to support its decision. The court agrees. End of quote.
Which we did then, we did submit,
You submitted a letter, but you did not address the.
we submitted findings of fact.
And I have the letter that I submitted.
I know you did, but we submitted the finding of fact and the judge ruled on that, and he upheld our decision.
He upheld the decision that the county has the authority to regulate land.
No, I
use
don't I
And to
disagree.
impose a penalty to those that don't conform. That's exactly what the summary judgment states.
And it said he upheld our decision to deny their request. He
On that
upheld,
basis.
upheld our decision, Paul. He upheld it enough that he fined him $40,000.
That's right, because he agreed with the fact the county has the authority to regulate land use and to impose a penalty for doing that. But he turned around and said in a companion suit that you didn't follow your own rules when you came to the decision process.
He didn't. He found us
Yeah, sure.
arbitrary on 2, but he upheld the decision. The final thing said, I upheld the decision. If he didn't uphold the decision, he would have remanded it back before he gave the penalty.
He gave a list of things to do to fix it. And they weren't fixed. You were using
He
subdivision
wanted us,
rules and regulations.
he wanted us to submit a finding of fact. We never would have got to the stage of the trial had we not resolved all those issues, Paul.
Yeah, would have, because he stated in here that he was not going to remand his original summary.
I don't agree. I don't agree with you. He said, I uphold your decision. After we went through the findings of fact and he came back to it, he upheld the decision. And then we went to the penalty phase. We'd have never got to the penalty phase had we not had a decision that upheld our decision.
Yeah, but he says.
To deny the thing.
He said that I uphold my original summary judgment. But in relationship to that, in other words, I uphold the fact the county has the right to regulate land use and to oppose a penalty, those wish not to conform. But then he turned around and said, but you didn't follow your own rules when you made the decision.
He didn't. He said, you were arbitrary in 2 of the situations. You weren't in the second one or the third one. It only takes 1 to deny the application. We denied the application and he said, I uphold that. You never got to a penalty because they wouldn't even have been in a penalty phase if they had a legal access.
He
I don't buy it.
with facts and findings that he actually said that the descriptions and the facts and findings that the commissioners wrote were cryptic. That means mysterious. They didn't even have a plan.
He upheld the decision after he had the findings of fact. We can argue about all the little nuances in the thing. When he said, I uphold your decision, that's the decision to deny them the act or deny them the land use change. We would have never got to the penalty phase had we not had won. If we hadn't prevailed, we'd have never got to the decision.
Well, I stated in a letter, and
So now,
this is anybody's, this is for the public as well. The letter that I stated in August 15th of 23. In that response letter you filed in response to the judge's request, pointing out all the errors that I perceived to be that was not in compliance with his request as a remand.
I understand, but your opinion on this matter and mine are way different. So we have a judge's ruling after we submitted findings of fact that said we uphold the decision to not grant them a land use change. And then we went to a penalty and he agreed with us in the penalty that they were in violation of that and fined them $40,000.
Are you in support of this going to the Wyoming Supreme Court?
Absolutely, if you're thinking.
Do you realize the potential risk that could have on our county?
So I talked about that whole deal about having to pay their attorney fees, and I heard that's bullshit.
I'm talking about what it costs the county just to go to Wyoming Supreme Court, not to mention the fact that the Wyoming Supreme Court should look at the whole.
We didn't go to Wyoming Supreme Court, except that we're defending our plan, and the Stevens have appealed it to the Supreme Court.
And when they appealed it, that basically says the judge's former decision is null and void and the Wyoming Supreme Court will determine.
I don't buy that. I don't buy that. So. I don't think you're reading that correctly, and you're not a lawyer.
I'm not, so that's for sure, and there's definitely a lot of legal language that's entailed in this whole thing.
I tell you, the judge
My letter response.
penalized them $40,000 for operating illegally. That looks like a significant decision on his part. So it wasn't as much money as we were asking, but $40,000 is quite a little money.
Can I have a question for Les?
Yeah.
You recommended, and the land use committee recommended a new application, correct?
Correct.
Has the land use plan changed? Which would affect any decisions on the Stevens? Has the land use plan changed over the last 2 years since the original application?
Yes. Yeah, there was an update in 2022. Their application came in, I believe it was in 2021.
Okay, that's all. Thank you.
So. We're here today to decide whether you have any interest in, either rescinding your motion or making a motion not to have the public hearing and to recommend to the Stevens to go through the plan. And I assume Paul does not, since he wrote us 2 or 3 pages here. You know what? I can tell you, it's a lot nicer if you're going to bring stuff before this board. If you would have the courtesy to provide that the week ahead for the Connie and put it in our packets, and we can have time to read.
Yeah, Tom, that would have been really nice had I known that Les was gonna present those letters before Friday night and Monday being a holiday. So I didn't have the opportunity to present this information in advance because I didn't know Les was presenting his letter.
Fair enough.
Right.
But I mean, we met on the 7th, and you know, the first thing I knew about the motion was you made it. Yeah, any idea what was coming? So you know, I mean, for us to be fair, just like, you know, I'm not gonna spend the next 5 minutes reading this in front of all these people, so.
No.
And do we have a motion to reconsider that?
No, the original motion that we made on the 7th.
Okay, well, my understanding of Robert's rules, I voted in opposition to that, and I can't really bring it back, so. But anyway, it take one of your. All right, so. Anything else?
No, that's all.
Okay. You want to give an update? Sorry, I had to follow all that. Yeah.
Quite all right.
Mr. Chairman, Commissioners, I'm Brooks Jordan, District Manager with Wyoming State Parks, and I'm here to give you a brief update on the status of the concession operations